Thank you. Thank you guys so much for having us. This presentation is going to discuss the disclosure of chronic illness to your employer, FMLA, the ADA, and disability as well. We're going to leave room at the end for questions, so please be thinking of those. Don't leave us up here just standing. Please ask questions, okay? So to start off with, I don't have any disclosures, neither does Sam. So nobody pays me except for Norton Healthcare. So here's that. Okay, so once you begin experiencing symptoms of a chronic illness, many questions emerge, one of which is when to speak with your employer. Disclosure sounds like an easy decision, but it's often not. So I wanted to have a little bit of participation from the audience. So somebody out there, several of you, shout out some benefits of disclosing your illness to your employer. Accommodations. Yeah? FMLA. Yeah, anybody have a supportive work environment and get some support from colleagues? Yeah, okay. So what are some drawbacks? Give me some drawbacks, some things that you're worried about and things that you really need to consider. Insurance? Stigma. A target? You know, all of those things are right. And at the end of the day, it comes down to a decision between yourself and your family, whether or not you're ready to disclose. So it's not something you want to jump into. Spend some time, think about it, think about your employer and your workplace. So we're going to jump right into FMLA. Somebody said that out there. So the thing to keep in mind is I am a social worker. I am not a lawyer. So my word is not law, unless you are my husband, in which case it is. So please be aware. All right, thanks. So jumping right into what is FMLA. So FMLA is the Family Medical Leave Act. It provides certain employees with up to 12 weeks of unpaid job protection leave per year. FMLA requires group health benefits be maintained during the leave. FMLA is designed to help employees balance their work and family responsibilities by allowing them to take reasonable, unpaid leave for certain family and medical reasons. I'll skip through some of them. Companies with 50 or more employees. Employers must provide an eligible employee with up to 12 weeks of unpaid leave each year for any of the following reasons, and you see those there on your slide. For the birth or care of a child, for placement with the employee of a child, for adoption or foster, for care for an immediate family member with a serious health condition, and to take medical leave when the employee is unable to work because of a serious health condition. Employees are eligible for leave if they have worked for an employer at least 12 months, at least 1,250 hours over the past 12 months, and work at a location where the company employs 50 or more employees within 75 miles. So in the context of this expo, we're going to discuss two forms of FMLA that are the most applicable. We're going to leave out parental leave for now. Intermittent FMLA refers to taking your 12-week leave in short blocks of time. So you see a few examples on your slide there. If you have an infusion appointment every other Friday for the next 8 weeks, you take intermittent FMLA for job protection for those particular Fridays. Or your mother's had a stroke and she needs to be taken to physical therapy 3 times a week for 6 weeks. You take FMLA for those times that she goes to therapy. The next is reduced leave, and this is where there's a reduction in the employee's usual number of hours worked. So due to your medical condition, your doctor requires that you no longer work 40 hours a week, so you take Mondays and Thursdays off. Your job requires you to stand 8 hours a day. Due to a medical condition, you can't stand for that long, so as a result, you move to a 6-hour workday and take FMLA for the remaining 2 hours. So please remember, Both intermittent and FMLA and reduced leave FMLA provide you with 12 weeks of time off and not a minute more. You will not be paid for FMLA. Your employer may have programs that will allow you to be paid. These can include PTO, sick time, but employers are not obligated to pay you for the FMLA itself. So when do you take FMLA? Well, you take FMLA when you or a family member have a serious health condition that prohibits you from completing the functions of your job. Now, this gets sticky when deciding what a serious health condition is. Generally speaking, a health condition is deemed to be serious when the employee is incapacitated for more than 3 consecutive days. It also includes 2 visits with a medical provider, and this includes mental health, done within 30 days of the incapacitated period. When you do need to take FMLA, you must notify your employer as soon as possible. Within 30 days is the ideal recommended period. You could do that if you had, say, a scheduled procedure, a scheduled surgery, and you knew 30 days in advance, which is not always the case. And your employer should have set policies for this. So this is your time to talk to your HR department, and they should have their own individual paperwork for these types of things. There are 2 important things to note. Your employer legally can call your providers to request validation of your condition. So be sure to sign your consents to allow your providers to speak with your employer so there's no delay in your paperwork. Because just because your employer can call the office doesn't mean that the office can talk to your employer. So sign those consents when you're in there. Employees may request recertification for chronic conditions only every 30 days. So unless there's doubt about the information provided, this means that your employer cannot pester you, they cannot pester your provider's office daily. I need updates, I need updates, I need updates. No, every 30 days. So what does FMLA not mean? Well, we spoke a little bit already about FMLA, so it doesn't mean that your employer has to make accommodations for your illness or disability. FMLA does not dictate accommodations at all. FMLA is about time away from work. So please don't take this to mean that you should never speak to your employers. You should try to talk through accommodations. But I say this to make you aware that it is possible your employer may say no to an accommodation for you to return to work. You may be saying to yourself, well, I have rights, and what about the rights of those with disabilities? Well, that's when the American Disabilities Act comes into play. The ADA, with regard to employment, is only applicable to employers with more than 15 employees. It requires employers to provide reasonable accommodations for employees with disabilities and prohibits discrimination on the basis of disability in all aspects of employment. Disability is defined by the ADA as a physical or mental impairment that substantially limits one or more of the major life activities, and the individual must have a record of such impairment, and the individual must be regarded as having such impairment. That's where your medical records come into play. So the issue with this is the ADA requires employers to make reasonable accommodations, but it doesn't clearly define what a reasonable accommodation is. So this leaves a gray area for employers and their attorneys to present their case that an accommodation is or is not reasonable. If the employer feels the accommodation puts an undue hardship on the company, they have the right to say no to the accommodation, and this is also a gray area. So if you experience this, then it's a good time to bring in your own attorney, or you can contact the ADA themselves. There's the numbers here, and each employer has to have a posted number for the ADA in their work site. So if you just jot down those numbers there, you can call them at any time and discuss your specific case and situation. So now I'm going to turn things over to Sam to kind of discuss about disability in a little bit more detail.
So actually, I do have some disclosures. I feel like I should. That's okay. I feel like I should get it out there. Definitely not an employee of Norton. I work at Schad Law Office over in New Albany, where I work primarily as a disability representative, where I've done that kind of work for the last 28 years. Through the years, we've developed this relationship with Norton. I assist patients when needed at the request of Norton, and I'm not paid by Norton, nor do we pay Norton to get that opportunity to speak with people. It's a trust-based relationship. Do a good job, Norton will have me speak with somebody, and vice versa. So the other thing I'll say to you before I get going on my part is I too am not an expert in this particular body of work discussion. Caitlin and I, through basically our years of case management, have to experience these topics every day. She had mentioned some, calling in the attorneys about, different attorneys about ADA. There are certainly many great attorneys in Louisville and Southern Indiana that you can call about employment issues. That's typically, if you're having a problem with your employer and ADA, you're looking for an employment attorney. You can also just search ADA attorney, and that'll pop up pretty much who you need to speak with. So what I want to talk about mostly is, ironically, how to avoid disability. Because what is FMLA for? What is the ADA for? Well, what it's really for is to keep your job, to hold on to your job as long as you can, so that you can figure out what you're capable of doing, and more importantly, what you're not capable of doing anymore, and then look to your employer to get the accommodations, to ask for the accommodations, and any other benefits that you can get. In general, when I'm speaking to folks about applying for disability, just as your employer would do with you, they're going to use you as a resource. They're going to use you for as long as they possibly can, because that is the nature of employment. You want good employees, you don't give up on them, you keep them around for as long as you can, and you use them as the resource that they are, for as harsh a thing as that may sound. And vice versa. Your employer is a resource. And that benefit that you get from FMLA is something that you are entitled to. You are rightfully given that opportunity. So use it. Use it to figure out what you can and cannot do. Use it to extend your employment for as long as you possibly can, because the goal is not to be on disability. That's the hard part. The other thing I recommend folks to do is, while you've got some downtime, you've got some time to think, hopefully it's a chance to recuperate, hopefully it's a chance to feel better. And while you're doing that, call the providers at work who provide the short and long-term disability policies if you have them. You want copies of those in your hand. You want to read through them. They're what I jokingly call a toilet read. You put them in a spot where you're not going to read them for good times, but they're there. And take your time with them, absorb them, get familiar with them. Because the short and long-term policies that some employers provide, and by the way, the other thing to say is, if you can get them, get them. If you go through an HR discussion with the employer and they're offering it and you can afford it, do it. Do it. It's good stuff to have. But the disability policies themselves also have some great benefits to keeping you employed. Sometimes, let's see what my next slide is. Sometimes they're going to give you other opportunities to work. These policies can be very flexible. What they want to do is, while you're out, while you've taken your FMLA and you know it's going to be a little longer, and you've taken your short-term disability policy, some of those policies will actually allow you to perform work with a different employer than the one who's providing the policy, just so you can make some more money. They will reduce what they pay you by the amount of money that you're bringing in from the job, but it gives you a chance. And I've had This isn't work every time, by the way. Not all policies for short-term are created the same. But I've had many clients who really appreciate this opportunity. They do a very physical job, or they're up on their feet all day long, and they really need an opportunity to try something else. And this gives them that opportunity. Hey, I went and I did a less physically demanding or a less mentally challenging job, and I was able to do it. So they can be very flexible. And the other thing to check on those short-term and then subsequently long-term disability policies is that you can kind of use it as a revolving door. You have to go out on short-term disability, you get a chance to do some treatment that makes you feel better, and you get back into work. And then, and I use both headache, MS, and seizures as a good example, there's sometimes a cyclical pattern to things. And eventually you need to do it again. So you want to read those policies about what the time span between those periods is and what else you can get out of the policies. But knowledge is power in this situation. And my part of this is, I think, pretty quick. The FMLA is fantastic information. And we'll be talking about disability later at 1:15, kind of some common myths about Social Security disability. But once there's this period of time that I get involved in very often of when do I finally say enough is enough. And only you know that. Only you on a day-to-day basis know whether you can wake up and put your pants on and go to work. At the end of the day, that discussion is something you need to share with your doctor and begin to have a constructive conversation about what life looks like after you know you can't maintain full-time work. And by this time, between the FMLA forms and short-term disability forms, it's probably going to be an old conversation that you have with your provider or providers. But what I found over the years is that's a big moment to say I can't work anymore. It also, and we'll talk about it later, it doesn't mean that once you file for Social Security, it doesn't mean that you can't work. So that's a bit of a myth. After you've been off on short-term disability, so the FMLA ran out, you took a short term, and if you're lucky enough to have the long-term policy, eventually the long-term disability company is going to ask you to file for Social Security disability. In fact, most of them insist on it because their goal is to, at all times, pay you less or not pay you at all. And you have to be cognizant of that. It's a company like any other, and that company is designed for one sole goal. Their first sole goal is always profit. It doesn't mean that they're evil. They provide a good product, and you just got to kind of keep that in the back of your mind. And they will ask you, they will insist that you do that. And many times they'll provide their own company to help you file for the Social Security disability benefit. There's a lot of them out there. They do a good job for the most part. We do the same thing. We're local. And it's all about a personal preference. It's whatever you are most comfortable with at the end of the day. They can't force you to use one of their companies. I'm trying real hard not to make that sound like a plug, but people need to know that you have a choice. They can't force you. The other thing that people call me about in this moment, in this point of transition is, when do I have to tell my employer that I'm going to quit or that I'm not there? Well, you don't actually have to do that. In fact, given the culmination of all of these benefits where one ties into another, and you've used your FMLA, you've got the long term, you've got the short term, your employer may even be head and above everybody else and have their own internal privately funded programs, which I have many clients who access those as well. Don't say you're done till they say you're done. Don't just give that up unless there's some kind of legal or financial reason to say, I quit. Stay employed as long as you can. And there are some some pretty viable interactions. So let's go back and kind of close on this. Medicare and COBRA play with each other a great deal. And I tried real hard to find the reg on this, but I just couldn't find the reg to show you. When you get on Social Security disability, if you've paid in enough, eventually you will be eligible for Medicare. Medicare takes 29 months to start after the date of disability. So from the date that you went out from work, Medicare won't kick in for 29 months unless, unfortunately, you have ALS, in which case it's immediate. But COBRA that you got from your employer because you didn't quit will only do 18 months. So there's a perceived gap. There's a worry that people have that they're not going to have coverage for long enough. Once you've been found disabled through Social Security and you're on a COBRA policy, that COBRA policy has to be rewritten to give you additional benefits that are COBRA'd at whatever rate that is until Medicare kicks in so that you don't have that gap in there. I think that encompasses all the kind of the little tidbits I wanted to get in, so thank you all very much.